of the pre-trial directions. I'll skip direction number 1, 2, number 1 and 2 in your own building. Go to direction number 3. Except where leave of the court not to disclose certain evidence on which the prosecution intends to place reliance in line with section 42 capital A of the CPC has been sought and secured in compliance with section 42A of the Criminal Procedure Code. The state shall be deemed to have complied with Article 52C and J of the Constitution and section 42 capital A of the CPC by doing the following. A, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present and the approximate time each witness is likely to take in examination in chief. B, preparing a bundle of documents, binding them serially, and originating them in a manner described in detail in the pre-trial directions. I will not read word after word. C, I'll go to D. The prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the advocate representing the accused before the next mentioned date. Upon service and to acknowledge receipt, the accused or the accused counsel shall sign against receipts of the same list of witnesses and bound documents. F, the prosecution is further directed to share with this court only the following: the tabulated list of witnesses and the tabulated list of documents. G, and most importantly, this code underlines that all copies of documents shared by the prosecution shall be identical to the originals held by the state. Direction number 4. A, hearing of this case will proceed on a day-to-day basis where so directed. B, on the days appointed for hearing, sessions will begin at 9:00 a.m. unless expressly advised or varied otherwise by this court. C, unless by dint of its nature it will be possible to do so, any interlocutory application whose inherent nature is likely to hinder or impede a hearing or is likely to cause an adjournment of a hearing should be filed with considerate reasonable time prior to the hearing D-Day. The direction should be issued for that matter before the hearing dates. D, any special need, for instance, the need for any special assistance to witnesses, intermediaries, interpreters, should be raised today or any reasonable period before the dates appointed for hearing. F, on the day appointed for hearing, no application for adjournment will be entertained and no adjournment will be permitted except where exceptional circumstances evidently beyond the control of the party desirous of securing the adjournment are demonstrated as detailed in direction number 5. And I want to take time on this one. In this court, we do not entertain applications for adjournment. That is to say, an application to take out a matter on the D-Day of the hearing. However, in lieu, this court entertains taking out a matter prior to the date appointed for hearing. And that you'll find the details in direction number 5 on how then to go about taking out a matter prior to the hearing date. Direction number 5. There are 4 mandatory notices. The first mandatory notice expected is a notice from this court if it is not sitting. You will get a written notice via many media, including via email and via text or calls, or a combination of the above. The second mandatory notice expected is a notice from any party. And this notice, except in exceptional circumstances evidently beyond the control of the party, no adjournment will be granted by ambush, or no application for adjournment is permissible on the date appointed for hearing by any party, except in the following circumstances: where a party is desirous of taking out a matter, all applications to take out a matter from the causes shall be raised and prosecuted way before the D-Day. And I've given 7 reasons why that is important. But I'll suffice to mention 3. First is trial certainty. Number 2 is to avoid unnecessary inconveniences to any of the players in this matter, including advocates, witnesses who have traveled long distances, including the courts. The third reason is that the judiciary has a no adjournment policy, and this is naturalizing that policy, that there should be no adjournment. Instead, there can be an option to take out, and once a matter is taken out, that date can be reallocated to another matter. But once a matter is adjourned, they will have no opportunity to allocate the date to another matter. Those are some of the reasons. The third mandatory notice is where an accused intends to withdraw instructions from the advocate. And the fourth and last mandatory notice is where an advocate intends to withdraw representation. Direction 6 is on time management. Parties are encouraged to keep time. I will not read everything. You will read for yourself. 6 directions under that. Direction 7 is on evidentiary objections. Evidentiary objections shall be deferred and raised upon completion of the examination in chief, immediately before the contested document is produced as an exhibit, except where the objection is of such a nature which cannot wait until completion of examination in chief. Of course, we have obvious examples which fall within that exception, including examination objections, the manner of examination, for example. That cannot wait until examination in chief is complete. Direction 8 is on plea bargaining. Without prejudice to the right to be presumed innocent until the contrary is proved, as granted by Article 52A of the Constitution, pursuant to Article 159(2)(c) of the Constitution, which obligates this court to promote alternative forms of dispute resolution, read in sync with both the CPC, that is sections 137 capital A through 137 capital O, read in further sync with the Kenya Integrity Plan 2023-2028, which too obligates this court to promote alternative forms of dispute resolution. Parties are at liberty to pursue plea bargaining, and these parties are encouraged to pursue it before the first hearing dates. Lead counsel. In circumstances where the accused person is represented by more than one advocate, but the accused is encouraged to organize his or her team of advocates in such a way that there is a lead counsel and the rest play a supplementary role. The accused is warned against offending. The statute is good. This will be explained by his advocates. And finally, variation of the direction. The direction may vary by this court, either sua sponte or upon motion of any party. You'll get copies of the
directions. Your Honor, I'm informed by Ms. Obiambo that counsel for the accused person from the firm of Okach and Partners Advocates was served with the documentary exhibits, and Your Honor, also the witness statements that we'll be relying on. Your Honor will, however, need to put in a proper inventory in line with your directions. As such, Your Honor, we are praying for 14 days to comply with the same. I think we can come back then for that purpose.